women's organizations had critiqued that if you bring in a uniform civil code, it would only be a majoritarian and a status quoist civil code. The present Uttarakhand civil code is neither there to advance women's rights, nor is the Uttarakhand civil code something which ensures justice for women. Edwa had pointed out that mere uniformity does not mean equality, and that for equal laws to be brought about, much more has to be done than merely having a uniform civil code, particularly in a situation such as the present, where the BJP government does not believe in equality for women, where its history of reform has been negligible, where its very basis of thinking rests on texts like the Manusmriti and similar texts which talk of subjugating women, which are casteist and which are against outsiders like Muslim. Civil Code, which merely replicates various sections of the Hindu Marriage Act and the Special Marriage Act, of the Hindu Succession Act, and so on. It doesn't introduce any new laws. It is insensitive to both beneficial aspects of Muslim personal laws and the discriminatory aspects of Hindu law. So it does nothing to disturb the patriarchy inherent in the current laws, but merely targets Muslim personal law and assumes that it is only that which is unequal. If you look at the sections on marriage and divorce, they are merely a replication of the Hindu law. In the Marriage Act, you have a section which says that you can get a divorce on the ground of conversion of one party to another religion. This was not there earlier. It also retains the inequitable right of an unconstitutional right of a right to conjugal relationship. Now, the remedy of asking for a restoration of conjugal relationship was a remedy which was there in Old English law and is now considered anti-human, and because it talks of restitution of conjugal rights by one partner to another. Similarly, there are other regressive features. It not only does it outlaw nikah halala, which many women from within the community had also asked for, but it goes on further to criminalize it. This is along the lines of the earlier law passed against triple talaq, which criminalized a man who pronounced triple talaq. The government seems to want to punish Muslim men with imprisonment. Another section which introduces criminalization is a section which states that if you don't get a divorce according to the provisions of the Act, you can be punished, again with imprisonment. This presumably tackles unilateral divorce. However, it doesn't take into account that under Muslim law, extrajudicial divorce has been made much easier by provisions of mutual consent and also by introducing a provision of khula, which is an inalienable right of a Muslim woman to ask for divorce. Instead, it tells all communities to go under the law and get whatever remedy it can according to the provisions in long drawn out battles in the court. Apart from this, the succession law doesn't take into account certain features of Muslim personal law, and which women's organizations had been demanding for a long time. The right to will should be curtailed so that daughters don't get disinherited, which the succession law doesn't take into account. Instead, it says that the same rules of succession will apply to Hindus and all others, forgetting that under Christian law, for instance, a woman can get half the property of a woman, of her husband, while her children had to share in the other half. Whereas under Hindu law, a man's property would have to be distributed between his mother, his wife, and his children in equal shares. Now, this law brings in a different thing and says that the property should be distributed in between, and one share should be given to the parents, not only the mother but also the father. Apart from this, the marriage section says that the estate of the parties can be divided in a way that the court considers fit. But that goes against everything that women's organizations had been asking for. They had been asking for a right to marital property, that is, a right to all the property that had been acquired during the marriage, because this recognizes a woman's worth, the productive worth. It recognizes that women, by being homemakers or by their caring duties, are also equally entitled to property of the house. A Madras High Court judgment had recognized this, but nothing has been done. Perhaps the most draconian portion of the legislation is the one which pertains to live-in relationships. Code tries to regulate these live-in relationships in the name of recognizing. The code says that these live-in relationships should be in accordance with the criteria for marrying under the Hindu Marriage Act, that they shouldn't be within prohibited degrees of relationship, that the other partner should not have a spouse living, and so on. And finally, that it shouldn't be against public order and morality. That means, and that all living relationships should be registered with the registrar, and the registrar can then make a summary inquiry into the relationship and ask for extra evidence. He can call people and summon the couple and subject them to scrutiny. So what does this mean? This means that the registrar, if he decides that a relationship is, for instance, against public order and morality, can refuse to register the relationship, which outlaws the relationship. This provision is unconstitutional. It is against the right to privacy and against the right to choose a partner of your choice, as has been held in Puttu Swami's case, when it said that nobody can decide who you should live with and who you should cohabit with. It subjects these couples, mostly young couples I think, though they can be old couples also, to the scrutiny of a kind which will make it absolutely impossible for these relationships to exist. The law is, this particular portion of the law is intrusive. It's meant to actually, it will harass people who want to live together and can ask them to produce what documents and subject to them to all kinds of scrutinies and make these relationships impossible, as I said.